Campaign for Criminal Justice Transparency was created in the fall of 2021. The CCJT in Kalamazoo began as a result of a community forum listening session. This forum was organized by the Advocates and Leaders for Police and Community Trust, ALPACT, in 2020, where community members engaged with Jeff Getting, Kalamazoo County's prosecuting attorney, and Josh Hilgart, Executive Director of Kalamazoo Defender. The goal was to identify advocacy goals for improving prosecutorial transparency and accountability. Community members expressed the need for access to information about prosecutions, demographics, and sentencing, leading to the idea of a publicly accessible database. The CCJT was created to address this need and promote transparency in the criminal justice system. In Kalamazoo, community members are coming together to push for transparency in the criminal justice system. The Campaign for Criminal Justice Transparency hosted a panel discussion where county prosecutors and defenders addressed questions and concerns about how the criminal justice system operates in Kalamazoo. Both pre-submitted and in-person questions were welcomed, allowing for an open dialogue between the community and those working within the criminal justice system. Ashante Collins, Executive Director of the CCJT, leads the Anti-Racism Task Force at Interfaith Strategy for Advocacy and Action in the Community, ISAC. Collins became the Executive Director in the fall of 2021.
We greatly appreciate your dedication to our mission of bringing transparency to the criminal justice system here in Kalamazoo County. Tonight, our panelists will be the Prosecutor's Office and the Defender's Office of Kalamazoo County. Our host, we have Carlton Mayers of Mayor Strategic Solutions. Carlton is a consultant that has been working with CCJT since 2020. He is the consultant who helped us write our open database resolution, which was passed in November of 2021. And then we do have some information about the open database. I have pretty little flyers on that right, the orange table back there. So I'll be able to pass those out as well. But Carlton has been a great help and a big part of CCJT and moving forward. And then we also have Angela Anderson, affectionately known as Double A. Angela is, is women's history. And Angela, I just want to say thank you. Every time that I've asked anything of you, you have shown up in service, sisterhood, and everything. So I just want to say publicly that we really, really appreciate you. You're always And so with that, I will actually pass the mic over. Oh, did I not choose one? Oh, sorry. Did I not say my name is Ashante Collins? I am the Executive Director of the Campaign for Criminal Justice and Transparency. And I'm going to pass it over to Josh for the
Hi, thanks for coming out. This is a pretty exciting event. I'm Josh Hilgart. I'm the Executive Director at the Public Defender Office, Kalamazoo Defender. And I'm also the Community Co-Chair for Advocates and Leaders for Police and Community Trust here in Kalamazoo, one of the sponsors of this event along with CCJT. And I would like to move this thing right along. I'm really going to let the chiefs in each department introduce their teams. And we'll start out with Matt Wade, Chief Defender at Kalamazoo Defender.
Good evening, my name is Matt Wade. I am the Chief Public Defender at Kalamazoo Defender. Next to me tonight is a level 3 attorney, which means in our office she handles high severity felonies residents. Thank you for being here.
Hello, everybody. How you doing? Good evening. Yeah, thank you. So we're going to now transition over into the questions part. So these were questions that were submitted by some of the people here in the audience, by others who are residents of Kalamazoo, to be asked of both the Public Defender's Office and of the Prosecutor's Office. And so some of them are just questions just for Prosecutor's Office, some just for the Public Defender, and some for both. So we're going to start now. I think we're going to start with a question for both.
Thank you, everyone. Glad to be here. Glad you all showed up tonight for this particular forum. Do want to let you know the responses will be timed, okay? So there you will be monitored on that if you get long-winded. If we have time afterward, of course, feel free to fill in and then respond to our community guests as you see fit. All right. First question. How do you define success on your job? And this is for either side. Just jump right in.
Hi. I would say that I define success in my job is helping to make victims in our community whole again after they unfortunately have been a victim of a crime. And I know there are some things that we'll never be able to do to help them achieve complete wholeness, but we do everything that we can, whether it be helping people find counseling services, getting restitution paid back to them, keeping them informed throughout the criminal justice process. One of the most important things I think that victims find very helpful throughout the process is being able to give a victim impact statement, which is at the resolution of a criminal case. The victim has the opportunity, if they wish, to let the accused, the judge, the court, everyone, how this crime has affected them, what it has meant to them, and what they would like to see happen regarding sentencing. And that is usually a culmination of weeks, months, and even years sometimes of work that our office does with the victims. And I think when we can leave a sentencing where the victim feels a little bit better, if not a lot better, as when the process started, to me, that would be success in my job. And I also love hearing updates from people, also letting me know how they're doing after the case has been resolved as well.
Thanks. Victims are a very important part of what we do, and hopefully that will come through your questions and our comments tonight. But leaving that part to Nora, I would just add that the criminal cases that come in front of us had a just out. Now, that's intentionally vague. You can say that's lawyer speak because I think every case is different. Obviously, victim cases are of special importance, so we need to have resolutions that make our victims whole, emotionally, physically, financially. We also need to send messages to the community that there are some behaviors we will and won't accept. Sometimes that's done through punishment, sometimes that's done through rehabilitation. But my version of success, what I would think is success for the cases that we handle is that every case is looked at on its individual merits and that we strive to come up with a just outcome for everyone involved.
Any responses on this? Before you all respond, please, I want to ask that you all announce who you are, say your name, okay, until we get used to that, probably throughout the whole evening. Go for it.
Hi everyone, so I'm Ellen Christie. Again, I'm an assistant public defender, level 3 at the Kalamazoo Defenders Office. So success for me is defined as success to my client. Your clients in this role as an attorney have different goals. Some folks want to get through this process as quickly and painlessly as possible. And other folks want to fight and they want to be heard. Some folks have collateral consequences that they're very worried about, that they need their criminal case to come out a certain way. So to me, success is always going to be what my client's goals are and getting those goals met to the absolute best of my ability. I'll pass it over to Taylor for her role as client advocate.
So So I'm Taylor, I'm a Chief Client Navigator. I work at the Village, which is the service hub for Kalamazoo Defenders. So we work to connect clients to resources in the community during the duration of their case, which could hopefully help increase the circumstances and maybe reduce the likelihood of recidivism, and also impact the criminal case in ways such as mitigation reports, humanizing them in front of the court. So success for me would first be a client leaving like they felt seen, that they came into our office, they felt that we acknowledged their perspective, that we put their needs at the forefront of the work that we do, that their self-determination really drove the direction of the work that we did, and that we led with their goals first, so that we could, help them connect to the resources that they need when they leave our care. Also, anything that we can do past that does directly impact the criminal case, like mitigation, so humanizing them in front of the court, showing the work that they are doing kind of in between court dates that really just captures the entire client, because they're more than just what's down on paper in the charge that we see. So we're working to humanize them. That's the holistic aspect of our office.
Matt Wade again, just briefly to add, it is client-centered, but it doesn't just stop there. Clearly our organization has an interest in bringing light to a system that is pretty challenging for those people that get caught up in it. So yes, it is to fight each and every day for the people that come into our office, but it's also to make a difference so that as we go forward, justice can mean something deeper than it has meant so far. And that's one of the things I think motivates each day the group that comes to work at Defendant. And so we're very happy about that. Like I said, anybody facing the criminal justice system, anybody that is dealing with something that could involve the worst thing that has ever happened in their life deserves somebody next to them fighting for them and standing next to them, because that's part of what this system is. It can be very dehumanizing, and all of us are valuable humans. So, thank you.
Okay, thank you very much for those responses. So now we're going to ask a question for the prosecutor's office specifically. This came from somebody in the community. How does your office make charging decisions?
Great, important question. When most criminal cases start when somebody usually picks up the phone and calls 911. The police investigate the case, they build their report, they present it to the Office of the Prosecuting Attorney. Usually what we have at that point is a police report. So that's where we start our evaluation of the case. We receive from police about 10,000 cases a year. We authorize around 6,000 of them, so there's obviously 4,000 that we receive that we don't charge for a variety of reasons. If there's a victim crime, we'll make every effort to get in touch with the victim. Every single morning, we have at least one victim advocate and at least one attorney who are just reviewing the domestic violence cases of the day before. It is our policy to reach or attempt to reach every single victim of domestic violence, so there's people making those calls, and the victim's role is part of it. At the end of the day, our office charging standard is a reasonable probability of conviction. I say to you without any irony, charging cases is an art, not a science. People have different views of things. A reasonable likelihood conviction for me, who's done dozens and dozens of trials, is different than somebody who's been in the office 6 months. If I've had experience with a case, that's something that I'm going to package in and look at whether or not we have a reasonable probability of conviction in this case. Now that doesn't mean that every single case goes to trial, far from it. There's a lot of pleas, there's a lot of really great supportive alternative justice programs in this county that people fall into, but that's what we look at. That's where we draw the line and say, is there a reasonable probability of conviction? Doesn't mean it's a slam dunk, doesn't mean it's an easy case, doesn't mean it's an impossible case, but somewhere on there that the person who reviewed it believes that there's a reasonable probability of conviction. I'll make one last point about that, and that is in acknowledging the fact that this is not a science. There are things that are against the letter of the law that we found that juries won't convict on, and vice versa. There's some really terrible things that it's really tough to have to tell a victim that, while this horrible thing happened to you, it doesn't meet the laws. We also have an appeal process. If anyone doesn't like our decision, if we deny a case or don't charge it as harshly as we think we should, a victim, a police officer, or a reporting party can call the office, a senior person will review the case and take another look at it there too, so there is a check and balance. Thanks.
Thank you.
That's okay. You took one of your partner's responses. Okay, for the defender side, does your office file requests for the court to dismiss charges against defendants when the case obviously has no merit?
Can you ask it again? Just, I want to make sure I answer.
Absolutely. Does your office file request for the court to dismiss charges against the defendants when the case obviously has no merit?
So, again, Matt, the simple answer up front is yes. If there is a motion that can be filed that is based in law and fact, we would always file those motions. The difficult part, and this is just a reality, and it kind of goes a little bit with the answer that Mr. Williams just gave, is that before any arrest warrant is issued, before an arrest warrant is issued, a judge or magistrate has reviewed the facts as alleged in the complaint and found that there's probable cause to believe that a crime has been committed, and so there's already a bar that's there, and so we are happy to file motions, and a lot of times what will come out is that maybe the facts that were alleged were what we thought they were, and so that brings a change of circumstances. So one of the things you have to understand when our attorneys stand up and make an argument that this case should go away because there really isn't a reason. We're also confronting a judge who has made a determination that there is a case to be made, and so that is part of that process as well. But all of us on the defense side have seen cases that you just look at and you go, okay. And those are ones that I guess they scare me because it's clearly somebody that's innocent that's been charged with a crime and is now facing it. When it's that obvious, a lot of times there will be relief. The closer ones are when there's, we do believe our clients are innocent on cases, and there's some facts that at least paint a picture that means trial has happened. Thank you.
Thank you.
Okay, we have a follow-up question for the prosecutor's office from the question that you just responded to. How does your office arrive at offers that merely permit the defendant to plead to the top charge?
In the ideal world, we look at every case independently, but I think it's also important that we have community standards. I think the system works better when people know what to expect. When police officers know what kind of charges what we're likely to do with each charge. I think the plea process and the even trial process, if we get there, is better if the parties are communicating and understanding each other. Plea offers are a huge part of that. Last time I looked at the numbers, it was upwards of 90% of the cases ended in plea one way or another. We give our assistant prosecuting attorneys, there are 30 attorneys in my office, they have a lot of discretion on most of the cases. There's certain things that our office, and when I say office at the end of the day, I'm talking about Jeff Getting, the elected prosecutor. It's not yours.
Oh, it's not. Move around. It's like trying to find Wi-Fi.
So again, back to the idea of plea offers. In felony cases, the first thing we start with is the sentencing guidelines. The legislature has set out maximum penalties for every crime, and for felonies, they're organized by grids, which are understood by letters. So we score the person's prior record, we score the person's what are called offense variables, basically the different things that they've done in this case, and that lets us know a range that the legislature has decided is appropriate, proportionate is the term that they use, so that's always a starting point. We have an idea from the legislature, and we have some discretion in there also. That's how we make a plea offer. I'm happy to answer that more specifically, but I also want to be respectful of that. Okay. Yeah, there, like I said, there are plea offers. Our attorneys have a lot of discretion, but on things like guns, a case where someone has been killed, or drunk driving cases are some very specific ones where we have some very specific numbers. There's always room for discretion, but the understanding is if you get a drunk driving case, your offer is not going to be as good if you hurt someone. It's going to be not as good if you damage property, which obviously is going to fall somewhere between harming another person and, having, the officer sees you weaving in the road, or maybe somebody who's passed out at the wheel. So we try to look at all those variables and make a fair offer, and quite honestly, the defense attorneys hold us accountable for that too. We're in a little bit of a different place. This may get into a different question. When we go to court, we represent the people of the state of Michigan. We follow the Victims' Rights Act. The Victims' Rights Act says we have to consult with victims. At the end of the day, we as prosecutors have to make the best decision we can make. And that's different from what KDI has to do, or any attorney who represents an individual. So obviously we'll come in with an offer, and somebody will say, well, what about this, what about that, and there's some back and forth. But again, we do try to keep a standard. We, unlike a lot of other offices in the state, we, as a friend of mine would say, there's the theory where you ask for a pony and be happy with a puppy. That's never been our view. There are offices in prosecution who will charge the most egregious thing that they can think of in the hopes that they can then plea the person down to the most reasonable charge. That brings us back to what I said about a reasonable probability of conviction. We look at the law, we look at the facts, and we try to determine what is the appropriate criminal charge under that, and we stick to that. As was mentioned in the crime, our general offer is to plead guilty to the most serious crime. Now, it seems like splitting hairs, but we use the term sentence bargain as opposed to plea bargain. We try to charge what's appropriate and hold people to that line. Now, we'll talk about making a difference if you're taking your recovery seriously and drugs or alcohol are involved. That obviously is going to make us vary from where we are. If you're acting as a result of a mental health crisis and you're working to address that and to do the things you need to do to not be a problem for society in the future, we're obviously going to take that into account also. And quite honestly, the folks at KDI are a really great resource in letting us know what's happening with the person and putting the best foot forward for their clients.
Thank you so much. Now we're moving into training and education offered. And we all know we need training in something, right? Right? Right. All right, there we are. Number one, does your office require all attorneys to attend implicit bias training? That's for either side. Please state your name and then respond to the question. Does your office require all attorneys to attend implicit bias training?
So again, Matt Wade, we have gone through this process a couple times. We were just starting our new inventory. I got my email this week. We will have training coming up in June. If you read about Kalamazoo Defender on our webpage, if you look at the founding principles that Josh Hilgard, along with others who created our organization, wrote, we are an anti-racist organization aiming to get after those things that for so long have gone unnoticed and that seem to permeate the system. And it's one of those things that we do take very seriously. We've gone through this This will be our second time going through the inventory process and working through that with our attorneys. And you would also know, if you talk to our attorneys, that we see a lot of this stuff, and we try our best. I'm not sure if it's implicit bias sometimes, maybe explicit bias, but it's things that we try to bring to the attention. And I will tell you, a lot of the times when we bring it to the attention of the prosecutor, they do understand and do work with us. But I am 47 years old. I've never been pulled over for turning into the wrong lane. I see police reports that say the only reason that police contact started was that they turned into the wrong lane. Just those kind of things exist, and they're things that we train our office to look for, because those are the kind of instances that, sadly for me, through the training that we've received and the life that I've lived, are the kind of fishing expeditions that are not aimed at really correcting the traffic ticket, but really trying to get into the car and see what else is going on. It generally does not happen to white citizens, sadly.
We require training. We require training for our attorneys. If you want something to write your legislators about, Michigan is one of the few states in Michigan that does not require ongoing continuing education for their attorneys. It's unfortunate, they should. So we as an office do that, we require training. We provide training. Implicit bias has been a topic that we have trained our office in before, and will continue to regularly, but I can't say in good faith that yes, it's a requirement and it's a box you have to check.
Real quickly, yes.
I was talking about implicit bias. Just so you know, the state of Michigan, when it passed the Indigent Defense Act, mandates now that any attorney handling indigent criminal defense has to have 12 continuing legal education hours each year, and in their first 2 years, I believe they have to have 16 hours of trial skills. This was one of the areas that was really problematic. I agree with Mr. Williams that the general attorneys in Michigan have no continuing legal education requirement. KCDI lawyers and those that represent indigent defendants who contracts with us do go through at least 12 hours a year CLEs. And I tell you, some of us get to 12, and that's where we can get based on our schedules. But we also have people in our office that love CLEs, and because of COVID, they're available online now for a lot less money than they used to be. And so some of them, I think, probably get 30 hours because they really do just voraciously want to be the best attorneys they can.
Thank you very much for that. Well, just staying along that vein of questioning, I do want to know more about the CLEs, the continuing legal education. So I just want to make sure we're clear. So in the state of Michigan, the maximum is, or the minimum I should say, is 12 hours that's required. Is that annual?
That's just for indigent defense.
Oh, only indigent.
So for just a civil attorney, perhaps they wouldn't have to go for any CLEs throughout the year. But for Michigan attorneys who are taking indigent defense cases, the minimum is 12.
Okay. So then my question is this, because we did receive a question from the community, or somebody in the community related to this. And I want to find out, so does your office offer CLE or anything like it, like any kind of professional development programs to your staff and also to non-attorneys? So that's for both of you.
Again, Jeff Williams, Prosecutor's Office. Yes, we do. Our requirement, again, it's an internal one that we have, not through the bar. We require at least 50 hours every 2 years. So that's our requirement. We let the attorneys choose where they get their training. We provide ongoing trainings. I think that's been important to me is for it not just to be attorneys to open people up. We have some probably more fun ones where we have canine officers bring in the dogs and show us off, and everybody likes that. And we have ones about trauma-informed prosecution, how to deal with victims who have literally had their brains rewired by the difficult things that they've experienced at the hands of their abusers. So we provide a variety. I noticed one of the things I think we'll talk about today is risk protection orders. That's going to be our next training coming up. So we constantly provide training. We're also part of the Prosecutors Association of Michigan, who provides for prosecutors. It sounds like similar to the training that indigent attorneys get also. Basic trial skills, how to prosecute a case, how to cross-examine a witness, how to give an opening, give a closing, that sort of thing. Thank you.
Hi, I'm Ellen Christie. Yes, so she's not here tonight, but our Chief Assistant Public Defender has actually told us attorneys it's her mission to put on a training for us at least once per month for the rest of the year, which is an ambitious and wonderful goal, but we have had internal trainings throughout our office. I'm newer to this specific office. I've been a public defender my whole career. I've been here 10 months. I don't know, Matt, maybe you can tell me if we have ones that have been open to the public. I know that we've done some training in schools and things of that nature. But as attorneys, our chief assistant is planning 1 month right now for us.
And we have done some other trainings that have been open to non-attorneys. A lot of them are within our office, but we are currently spending some time developing ways in which we can reach out to the community and be a deeper partner with those people in the community and help them understand the system, how it works, how they can navigate it more safely, and what changes and opportunities exist. And just briefly, our deputy chief did walk in, so she's here. She raised her hand right close to here. She's snuck in.
Just the last one I want to ask as a follow-up, because we are talking about training, and I know that there has been, ever since 2012, a movement, not only with law enforcement, but also with other actors, with our entities within the criminal legal system, including prosecutors, public defenders, judges, etc., to receive mandatory annual trainings. I know we talked about implicit bias, but I know another one that's been coming up a lot has been trauma-informed care. Can you speak a bit about that, both of you, please?
Hi, this is Nora, victim advocate. So I know that we had a required training where it was based on an ACE score, the adverse, I believe, childhood effects of trauma that I believe everyone had to complete. So we definitely have that, and then I've been to several myself as like a non-attorney staff member for our office to several trainings that look into neurobiology and effects of trauma. I'm actually going to a virtual training Monday morning that has to do with animal abuse and domestic violence. So I will say there's also great ample opportunities. And all of these trainings also, most of them, at least when I go to them, it's a collaboration of assistant prosecutors, victim advocates. Some are open to judges, legal assistants, anyone really in the criminal justice system. But I have also too noticed and seen and been to many more trauma-informed and focused trainings as of late, which I think really helps to understand. When you see a victim and when they testify, sometimes someone may not understand why they're saying what they're saying or the reasons behind it, but then when you can explain that how the neurobiology changes the brain and trauma, it really kind of lets everyone see the bigger picture of what has happened.
I'll just briefly talk from the legal side, and then I want to make sure that Taylor Sayers can give you an update from us, because it is about complainants, victims from the prosecutor side. It also happens to our clients, right? A lot of our clients come from a place where they have suffered lots of trauma. Prior to being here, I've been on the other side. I've been a prosecutor. One of the big things, as you guys know, every year they're understanding more and more how the brain works and just the miraculous different ways that the brain does stuff. And so there's a technique out there, it's called the FETI technique. It's a way to try to get at information that is stored in a person's brain that is not recoverable using the normal processes, right? But that might be triggered by sight, smell, sounds, stuff like that. And there's a whole training on how you can go through that. I've been through that. It's something that I would like to get more for our attorneys. We haven't found it yet. But the reality is we're dealing in our office with trauma every day. And that's why I want to turn over to Taylor, because she has a little bit more information about this.
Okay, we have about 30 more seconds on this side.
Okay, again, Taylor Sayers, I'm the client navigator, the social work side of the office. And so at its baseline, social work is trauma informed. All of our social workers have a master's degree, and so many of us have gone through a lot of schooling that is trauma informed. Then once we've been in the field, I know that part of my onboarding into the client navigator role was about trauma informed care and ACEs also. We use that, and about the trauma responses, the biological component of trauma. So when we're doing mitigation work, trauma is typically a huge part of the focus to uplift a client's trauma and try and contextualize that into like the current incident and why that played a role to hopefully impact the outcome that that client may see. So we have done national level trainings, we have done E-race trainings, we have done multiple, I guess, in the community and continue to look for opportunities within ourselves. But I would say that that's typically the lens of our work because it is very much the forefront of what we see when we are needing to approach the general public.
Thank you. Okay, in the interest of time, I just want to remind you all that we have 2 minutes per side per question, and we do have Hello? We're here. Okay, we have 2 minutes per side per question. In the interest of time, we want to make sure we're mindful of that. If you hear me say thank you, that means kindly stop your response. We know you have a lot to say, but we do have just a little bit of time, okay? And we definitely want to get through majority of this list. So, under Zoom court hearings, Carlton, I'm going to pass it to you if you would read both of those questions and give room for answers.
Okay, so we have 2 questions here for both sides. One question is, what laws, if any, are there related to court hearings for public viewing via Zoom or any other video call option? And then just under that is, what is Kalamazoo's policy for Zoom court hearings? So if you both could respond, whoever wants to go first.
Jeff Williams, I'll start, and Matt can jump in or add on. The state of it, I'll go back a bit. COVID, nobody ever did anything. Your feet needed to be in court. Everybody needed to be in court, and if one party wasn't there, you weren't having a hearing. That changed during COVID, and it changed very quickly, and it changed more quickly than any of us thought. During that time, we just wanted to keep cases moving. It was unprecedented for a lot of reasons, and the State Court Administrator's Office satisfied that, encouraged the use of Zoom. I would argue is continuing to encourage the use of Zoom, but there is a great presumption in the law that the specific judge gets to run their courtroom and gets to make the decisions. I am not aware of any courts in Kalamazoo doing regular proceedings by Zoom. We've had a few unique situations. Unfortunately, I appreciate the judges who have done this. We had a homicide of a family down in Portage, and the victims have a right to be present. Fortunately, the judge who handled that case, and the defense was on board with this too, allowed the victims to log on via Zoom so they could watch and hear, and even if they chose to, gave a victim impact statement from miles away. They didn't have to leave their home. We didn't have to use taxpayer money to fly them here to satisfy victim rights, but that's about the most that I've seen happen in Zoom in the last couple of years, and at least from my perspective, it's something that the judges just haven't been interested in doing, at least as a whole. I don't speak for them, but I can say that it's simply just not happening right now, and I wish it was, honestly.
I would say that on the side of public, I don't believe that our county anymore broadcasts court proceedings over the internet like they were doing. I think that was something that people enjoyed, brought real concerns to The defense bar in the sense that you didn't know who was watching stuff. A lot of times in trials, there's sequestration orders, other things like that, that you're trying to protect so that you know that the people that are in the room have not been privy to other testimony so they don't, testify in a certain way. So I don't believe we use Zoom hearings that way. We still do use Zoom hearings for arraignments in our office. So somebody's been arrested and is lodged at the jail, they will be on a Zoom camera with Judge Jones or any other district court judge if it's a new case, possibly in circuit court if they've missed a case up there. But we use Zoom. It's sometimes tough to talk with the clients, so we ultimately try to get them in court. And there is provision under law that does say that the defendant has a right to be present.
Thank you. And we're moving to victim impact.
Okay, so for victim impact, this is going to be a question for the prosecutor's office. What influence does the alleged victim in a case have on the potential settlement offers to which your office might agree?
Reminder, we have 2 minutes for a question, okay?
Yeah, I'll say a little bit about the procedural part of that and then pass it over to Nora. But there's nothing more for it, quite honestly. There are different plea agreements people come to get my feedback on as the chief assistant, and if you're in my office and you haven't figured out, that you better have called the victim and find out how they feel about this agreement before you get my opinion. You're not really paying attention, quite honestly. My first question to everyone is, what does the victim want? How do they feel about this? And where are we at? I also think when we say victim impact statements, that's kind of the term of art that's used for a victim's right to actually be able to address the court. Whether it's me or Matt or the most talented advocate here, judges hear from us every single day. They don't hear from individuals. And there's nothing for me, and I can only assume for the judges, like hearing the person who's lived that. So it has a tremendous impact on me in my office, and from what I've seen, it has a tremendous impact on judges also.
I will also say, because I do spend most of my day talking to victims, that there are several times where their input is so powerful on the final resolution of the case. There are several times where someone's like, I just want this person to get help with drinking, and that's all I want. I think these are appropriate, consequences for what they did. And that is something I think that greatly impacts the ultimate outcome of a case. They're in the same vein, there's other people who want something a much more severe consequence that we, the law, no judge would ever provide as a potential outcome to a case. But I would say that there are so many options that we discuss with victims, and there's been many creative solutions that have come about.
Thank you so much. For the defender's side, how often do you represent clients who is alleged victims but do not cooperate? The follow-up to that while you're thinking, how does this typically affect clients' case moving forward?
Sure. So I think it depends on the kind of charge often. There's different charges and varying cooperation from complaining witnesses that we see. I think generally, and sometimes in some assaultive cases, complainants are less likely to come to court. Now, if they don't come to court, at least in a felony proceeding at the preliminary examination stage, which is the stage in which probable cause has to be shown for that charge, oftentimes that charge is dismissed without prejudice from the judge. So what that means is that the prosecutor's office could opt to refile those charges. The problem from my perspective or from the defense perspective might come in where if that warrant gets reauthorized for that person, they may not know that there's a warrant, and they could be arrested at any time on that warrant because that person had to come to court earlier. That's my perspective. I think it's not super often that people don't cooperate, but it does happen more often than I think the general public might think.
It's in the cases you guys would most likely think about. These These are domestic violence, assault and battery, those types of crimes where, families are involved, and it's more complex than just a case, right? Because they're likely going to be living together. I mean, the toughest part, and this is something that, if you know people that are involved in this, it's important. Once you're involved in the court system, once a judge has set a bond condition that says X, Y, and Z are prohibits it, even if the parties reconcile, that's not enough because there's a court order. And I cannot tell you how many times we are able, Kalamazoo judges are often very fair on these cases on setting protective conditions and setting PR bonds, but then we get clients in return because parties have gone back to a status quo, but they still have a case, and that is something they have to resolve first.
Thank you.
Okay.
And Carlton.
All right, so now we're going to talk about PPOs, personal protection orders. Question we have here is for a personal protection order, what is the proper protocol to obtain one? And then the follow-up question is, what are the challenges to getting one? Oh, sorry. Yep, sorry. Yeah, that's for the prosecutor's office. Sorry about that.
Jeff Williams from the prosecutor's office. Personal protection order, people call it restraining orders, or it's basically a court order saying that somebody can't do something. Most often it's person A cannot have any contact with person B. I think they're a tremendous tool. I always recommend them, even if there are other bond violations in place. If someone is harassing or threatening you and you want them to go to jail, hope they violate their PPO, because they don't mess around with PPOs. If a judge orders you not to have contact with your ex or person you're stalking or whatever, and you do, you're probably going to spend some jail time. The police are going to see that PPO is active and pick it up. PPO is meant to be favorable to the individual so that you don't need an attorney. There's a court form that you fill out. The general standard for it is that you are in fear, you've either been threatened, terrorized, harassed, or assaulted by a person. So the facts of a domestic violence, regardless of whether or not criminal charges, are often the basis. There also is a PPO coordinator at the new courthouse on 330 Eleanor, the Pratt Justice Center. Her job is just to help you fill out that form and get the information there. But it's a wonderful way of giving people an increase in protection. Too often, it's frustrating for us as prosecutors, you have to wait for someone to do something awful before the police can act, before we can hold someone accountable. PPOs give you a measure of protection that you don't have to wait until the person harms you or puts your hand on you. The fact that they're hanging around in your front yard or you see their car driving around the block is enough, because the judge has said, hey, there's a history here. There's a court order that you aren't to have contact with this person. So tremendous resource, easy to get. I strongly advise people to do that if they have reason to fear.
Thank you. Defenders, can you please clarify ERPO, extreme risk protection? I won't tell the whole thing because you're going to explain that. ERPO and the difference between PPO. ERPO, ERPO, Extreme Risk Protection Order Act of Michigan. And then what is the difference between that and PPO?
I think you're talking about the new law that they just passed. Is that what you're talking about? Yeah. So, yeah. In a minute, I will turn this over to the prosecutor because this is something they have much more. So the reality is the Kalamazoo Defender is appointed on criminal cases or PPOs when there's been a violation. We do not have a civil arm that addresses or helps respondents of PPOs prior to there being a violation. So that's where people are required to either go to private attorneys or to represent themselves. The new law that was passed about whether or not somebody's a danger to themselves and the police can go get their guns, that's something that the prosecutor's office is wrestling with and law enforcement is wrestling with. It is probably the most scary new litigation area that the prosecutors and the police have faced probably in the last 30 years, I would assume. PPOs are simply between parties. There's always been civil commitment proceedings that have happened in probate courts, but this takes it to a different level. That's all I really know about it. So we don't practice much in that area.
Absolutely. ERPO's extreme risk protection orders are part of a package of laws that was passed by the legislature, largely in response to the school shootings on the east side of the state. The group of laws, ERPO is one of them, widely known as red flag laws. Laws intended to keep specifically firearms out of the hands of people who a judge decides should not have them. That can be based on their mental health, it can be based on threatening behavior, it can be based on a prior conviction, but it is a PPO-like process in that anyone, an individual, a police officer, a prosecutor, can petition a judge to say that this person can no longer have guns. There's a few machinations of that, depending on the situation. There's an emergency one where the police go to your house right now, kick in the door, and take out every gun in the house. As you can imagine, I don't know anyone in law enforcement who's looking forward to having to do that or receiving that offer. Not to say that it isn't very important to keep firearms out of the hands of people who should not have them. There's other situations where a person can have, the judge will say, okay, you have 24 hours to get your guns to a safe place, and you prove that to us, and you come in and say on the record, and maybe we'll send an officer out. I won't bore you with all the details, but it allows a person to petition a judge to say, not only you shouldn't have a firearm, which is a pretty common bond condition, but the police are going to come. And usually the first step, I believe, will be, please to give your guns to the police. You have 24 hours to do that. If you don't, the police can then come to your house.
Thank you so much. Carlton.
We're going to move over to victims' rights at this point. Okay. So the question we have here is, and I want to say you might have answered part of this already, both of you. This for both of you. In what ways does your office support victims' rights? And it's going to be two follow-ups from there, being what resources are provided to victims by your office? And then lastly, how can victims assert their rights? So I think you can probably answer all of that in one. So.
Right. So as Jeff had mentioned earlier, there is something in the Constitution and the law of Michigan called the Victims' Rights Act, where victims are granted certain inalienable rights under the law in Michigan. One of them is being able to give your victim impact statement, be aware of court proceedings, and be involved in potential negotiations. It doesn't mean we're always going to do whatever a victim wants, but we're always going to take their input into consideration. I'm sorry, what were the other two?
Essentially, like what resources are provided by your office, which I think you just touched on, and then how can victims assert their rights? And I think you might have touched on that as well.
So there's several different resources available within our office and within Kalamazoo County. I think we have a lot of community partnerships with the YWCA, who I see has a table here today, and other community organizations, whether it be ISK or there's like housing resources. There's several ways we try to connect victims with the resources they need. There are several instances where victims may have nowhere to go after a domestic violence incident. They can't go back to the home they were at because it's the defendant's home in some instances. Other times they need to have their locks changed, and we can provide resources for that. We have some access to emergency funds, which can also help people with monetary costs, such as being able to get to court and changing locks if they need to, or even help in resources with childcare. And actually one of the most important things is crime victim compensation, which is also a program through the state of Michigan. And there's this huge fund out there, and I always tell victims about it, and they actually just changed the legislature this past August for what all CVC can cover. It helps victims get paid back for their medical bills that they may have incurred. It can help with counseling costs. It can help, unfortunately, if there is a death involved, it can help pay for some funeral costs. So these resources are out there, and there's an office in Lansing that we can always connect people with, we work closely with, to help them get access to those funds, because it's much quicker for someone to get those funds to pay their medical bills back than waiting for someone to pay restitution. And then typically someone has to pay restitution to the court, and then it goes back into the Crime Victims' Rights Fund. But it's a great way to at least help people with some of those initial needs and out-of-pocket services.
Thank you. All right. Next question, enforcement of misconduct. And this goes to prosecutors. What does your office do when one of your staff believes that a police officer has lied or failed to maintain the standard law enforcement which they should be held? And the follow-up to that is there an official policy? Is there a public Brady list to which all such law enforcement personnel are added?
Yes, yes, and yes.
Okay.
For those who don't know, as a bit of background, there is a series of laws that we call by the case names known as Brady and Giglio. Brady generally says that if you're a prosecutor and you have information about the case, even if it helps the defense, actually, especially if it helps the defense, you have an affirmative duty to turn that over. That case has evolved what is considered Brady information, what we call it, information that immediately has to be disclosed. As a practical example, if a domestic violence victim says, I know what he did to me, but I just can't go forward with this anymore, and I don't want to testify, or I'd rather you dismiss this case. They haven't contradicted themselves, they haven't said anything untrue, they haven't restated the facts. I would say that is not Brady information. If the victim says, I lied, I punched the other person first, or I didn't tell you about A, B, and C, we have an affirmative duty to provide that to the defense. The case of Giglio has expanded Brady to include information of police officers where their credibility might be in question. And if that sounds broad, it is, then I think it should be broad. My duty as a part of the prosecutor's office is to regularly ask all of the police agencies in the county, is there anyone in your department who's currently a sworn officer who may have done something that would make them fall under Brady? They provide that to us. We get the information. If that information is substantiated, and I'll be honest, it doesn't take a whole lot. They go on what we call a Brady list. There's a list of officers who are what we call Brady impaired. There's something in their past. It may be work-related, it may not be work-related. When I train police officers, I tell them probably one of the worst things you can hear on the stand is when somebody throws up their social media account on a screen. That's all relevant. We keep track of it and make sure the defense knows about it too.
So Jeff, really quick, part of that question was, is that list public? And if so, public where?
I believe it's a public list. I don't know that I've ever been asked that question. I don't know why it wouldn't be. We in the past haven't published it. We provide it periodically to all of the defense attorneys that we can find, but I would want to double check the law to make sure it's not expressly not to be shared, but it seems like it should. Yeah, and I think that you bring up a great point. I think that is something that would be beneficial to the community. The law, which we try to treat as a floor, not a ceiling, requires that we provide it to the defense. I don't think there's any requirement that it be made public, but I think that's certainly something to think about. Sure, thank you.
So again, potentially foiable.
Oh, yeah.
Definitely foiable. Carlton.
All right, so we're going to move into human trafficking. We have one question here. This is for the, well, I guess let's go to the defense because we just have the prosecutor's office. How often does your office inform clients about community-based advocacy programs that can help them during and after the court process who are survivors of domestic violence, human trafficking, and other similar charges?
Taylor Sayers, client navigator. I would say that it completely depends on the kind of the information we get through the case. So client navigators work very closely with clients, and typically we build a rapport where information like that may come out, and we try our best to make sure that clients are informed early on in the process, so that we can ideally build a relationship while they're still our client, make sure that they have a contact person, that soft handoff. It's very intimidating to kind of move into a new space and not know how you're going to be perceived. So our client navigators strive to be advocates that will go with you somewhere and make sure that you're kind of getting off into the right hands. So I would say that if it seems right for the case of the client, if it's led by them, it's something that they're interested in and express a need for, then we're going to do everything in our power to both share the resources we know about, and if those aren't adequate, find others, because part of our job is always finding more resources, because there are a lot out there and they're very siloed and hard to access. It's hard for our team. I imagine it's extremely hard for clients with us.
Thank you.
Thank you. Real quick, audience, how are you doing? Let's hear you. Clap, yell, stretch, do something. Are you ready something for this?
So I just want to say I'm hearing people in the audience saying that they're ready to ask questions.
This is why we provided you with little notebooks, because y'all have a whole section where you will be able to ask questions. So we're going to do this, the online submitted questions for people who aren't here or may not have wanted to ask it in person, and then we have a whole other section right after this to allow you to do it.
How much time is allocated for audience?
Same amount, 10 minutes.
Same amount of time. So those cute little books, please get those things out. Write your questions down as we continue to roll on. We'll be done with this section in a few moments, okay? Okay?
Sound good? All right.
Thank you so much. Another side to that, in the area of human trafficking, how often does your office inform clients about community-based advocacy programs that can help them during and after the court process who are survivors of domestic violence, human trafficking, and other similar charges? How often do you inform the community about that? Sure.
As much as we possibly can. Unfortunately, we're losing victim advocates, our resources are getting cut, and we've had to focus on being more of an opportunity, pointing people towards other opportunities, a conduit, I'll say, to get people to the why, to get people with groups that can help them. That's one of the things we're good at. I would love to have the resources to be able to bring in people and provide those services ourselves, but that's not the reality of the way things are right now, and that's the more we know that, the more we can do that. We have people working with the Child Advocacy Center, the Human Trafficking Group, the Child Death Review, the Elder Death Review. We're being out in the community as much as we can, so we know about those resources so we can provide them to other people. And human trafficking is an excellent example where education is a huge part of that program.
Thank you so much. We have 30 seconds. Anything?
Well, I think Taylor said a lot of it. I guess I would add, the defense position is sometimes one of those where we defend people who have been trafficked, and that is why they're committing their crimes. That has happened before. We've had those defendants. Sadly, we're also the people that represent people that are alleged to have trafficked, and so it's our job to provide them a defense as robust as anybody else, and so that is what we do. Domestic violence cases are very difficult, especially for prosecution, because they need a complaining witness, and a lot of times complaining witnesses in those cases do not go to court. So, yes.
All right. Thank you so much. We are going to, we're getting near the end, we're getting near the good part where you guys can ask questions, okay? Okay?
Okay.
Thank you. Violent crimes, Mr. Carlton.
Okay, so violent crime. So this is in reference to pretrial. Why are individuals who commit violent crimes not prosecuted? For example, charges dismissed without a trial, or they get out on bail. So that's for the prosecutor's office.
Yeah, great questions. Like a lot of things in the system, we're the ones up here, and I think this is an important event, but whatever the issue is, we make an argument to the judge as prosecutors, the defense attorneys make an argument to the judge, and the judge is the one who, at the end of the day, imposes the sentence, decides whether or not to accept the plea agreement, or in the terms of the question you asked, sets the bond. We had a person who shot up their girlfriend's house a couple days ago. We asked for a $50,000 cash surety. They were released on a PR bond. The victim is currently hiding out of state and won't even tell her parents where they are. We asked for $50,000. That wasn't there. It's not a KDI case for whatever it's worth. We're stuck with it. That's the decision the judge found. That's what the judge found was appropriate, and the judges get the final say. With regard to cases being dropped, violent cases are the most important cases we've handled, and unfortunately are increasing in number. And the more violent ones are certainly the cases that are increasing the most in this community. The reason we don't go forward in those cases is the same reason we don't go forward in probably the large majority of cases, is nobody wants to come to court and say what happened. I would respectfully disagree with what the KDI person said when you asked them how often do cases get dismissed because the victims show up. The first word that popped into my head was a lot. I would even say at least half, probably more than half, are just because the person doesn't want to go ahead. And we do our best to respect the individual. One of the things I've learned in this job is that the victims and the people who are living lives where bad things happen, they're the expert in what's best for them and being strong and healthy and going forward. And when people make the decision that they don't want to come forward, there's really not a lot we can do. The law does allow us, the letter of the law would allow us to have someone held in contempt, but to me that's just re-victimizing a person who's already been through something terrible.
Thank you. Last question before we move to the next. Appreciate you all very much. Prosecutor side, when a resident suspects inaccurate reporting by law enforcement, what is the correct procedure to file a report with your office?
If there is incorrect information in a police report, I absolutely want to know about it. But I think the issue there needs to start with law enforcement. And there's a couple issues here. There's one, making sure we have all the correct information. So like I said, our goal is to get a just outcome. And we can't do that if we don't have all the facts. So there's getting the right information for your case. That if you have a defense attorney, that's a great place to start with that. There are mistakes in police reports that are just mistakes. Police officers have to take in they have to synthesize a lot of information. They have a pad like what you guys have in front of you, and they got to take 6 different statements from 6 different people while they're also clearing the house to make sure that everyone is safe. So there's errors in that way. Now, if there are ongoing errors in police reports, if there's errors that are more than just, I'll use the term innocent mistake, one thing that's really helped accuracy reports are body cameras. I think body cameras help out everyone, and sometimes what's in the body cam is not what's in the report, and that's a real important thing to us. I would say let your defense attorney know, let the prosecutor handling the case know, but take that a step further if you're comfortable. Look into the police department, find out that person's supervisor, because there are people on the gig wheel list who are there because their body camera just never matched up with what was on paper, and that was the reason they're no longer police officers.
Okay, so at this point, we're going to start with the Q&A with the audience. So the way we're going to organize it is that I'm going to pass the mic around to individuals in this area who raise their hand with a question, and Angela is going to do it for individuals in that area who have a question, and then Ashanti is going to be, I guess, moderating it.
No, she's still doing my job. Yeah. Just a couple of house rules. So this is our first time doing it in person, and we're doing in-person questions because it has been requested, by the community, and so we wanted to make sure that we provided that opportunity for everybody. If you ever submitted questions online for any of our forums, it's just the same. There are questions that they legally cannot answer. Also, confidential information, confidential information or anything that has anyone's name specifically, we cannot ask those type of questions. They cannot and will not answer that. So I would say try to make it as generalized as possible so you can still get your point across when you are asking your questions. And they will still have 2 minutes to respond to your question. And if for any reason that we do not get through all of the questions, in the back of your little books, there is a QR code. And so if we cannot get to everyone, if you do still have questions at the end, use that QR code, write us the questions, and we'll take care of that afterwards. Thank you. So we're going to start. So if you could just raise your hands, Angela, James, actually, go ahead.
How y'all doing? This question is for prosecutors. Y'all say the victims, that's what I've been hearing all night. 9 times out of 10, on court proceedings, I see the people versus the defendant. So in situations like that, who is the community that you're helping? Who is the victim?
Not every case we handle is a victim case. Drug cases are an example of one where, in theory, the victim is the community because there's bad things that happen in the community when people do drugs. Not my idea, but that's kind of the way the law looks at it. We do represent the people of the state of Michigan. The county votes on who should be the prosecutor every 4 years.
I am 47 years old. I have never been pulled over for turning into the wrong lane. I see police reports that say the only reason that police contacts her was that they turned into the wrong lane. Just those kind of things exist, and they're things that we train our office to look for because those are the kind of instances that, sadly for me, through the training that we've received and the life that I've lived, the kind of fishing expeditions that are not aimed at really correcting the traffic ticket, but really trying to get into the car and see what else is going on. It generally does not happen to the white citizens. Sadly.
And you want them to go to jail, hope they violate their PPO because they don't mess around with PPOs. If a judge orders you not to have contact with your ex or person you're stalking or whatever, and you do, you're probably going to spend some jail time. The police are going to see that PPO is active and pick it up. PPO is meant to be favorable to the individual so that you don't need an attorney. There's a court form that you fill out. The general standard for it is that you are in fear, you've either been threatened, terrorized, harassed, or assaulted by a person. So the facts of the domestic violence, regardless of whether or not criminal charges are often the basis. There also is a PPO coordinator at the new courthouse on 330 Illinois, the Pratt Justice Center. Her job is just to help you fill out that form and get the information there. But it's a wonderful way of giving people an increase of protection. Too often, it's frustrating for us as prosecutors. You have to wait for someone to do something awful before the police can act, before we can hold someone accountable. PPOs give you a measure of protection that you don't have to wait until the person harms you or puts your hand on you. The fact that they're hanging around in your front yard or you see their car driving around the block is enough because the judge has said, hey, there's a history here. There's a court order that you aren't to have contact with this person. So tremendous resource, easy to get. I strongly advise people to do that if they have reason.
It doesn't mean we're always going to do whatever a victim wants, but we're always going to take their input into consideration. I'm sorry, what were the other two?
It's essentially like what resources are provided by your office, which I think you just touched on, and then how can victims assert their rights. I think you might have touched on that as well.
So there's several different resources available within our office and within Kalamazoo County. I think we have a lot of community partnerships with the YWCA, who I see as a table here today, and other community organizations, whether it be ISK or there's like housing resources. There's several ways we try to connect victims with the resources they need. There are several instances where victims may have nowhere to go after a domestic violence incident. They can't go back to the home they were at because it's the defendant's home in some instances. Other times they need to have their locks changed, and we can provide resources for that. We have some access to emergency funds, which can also help people with monetary costs, such as being able to get to court and changing locks if they need to, or even help and resources with childcare. And actually one of the most important things is crime victim compensation, which is also a program through the state of Michigan. And there's this huge fund out there, and I always tell victims about it, and they actually just changed the legislature this past August for what all CDC can cover. It helps victims get paid back for their medical bills that they may have incurred. It can help with counseling costs. It can help, unfortunately, if there is a death involved, it can help pay for some funeral costs. So these resources are out there, and there's an office in Lansing that we can always connect people with, we work closely with, to help them get access to those funds, because it's much quicker for someone to get those funds and pay their medical bills back than waiting for someone to pay restitution. And then typically someone has to pay restitution to the court, and then it goes back into the Crime Victims' Rights Fund. But it's a great way to at least help people with some of those initial needs and out-of-pocket services.
Thank you. So we have another question over here. Thank you.
Hi, my name is Lena Shorter. I'm with the Participatory Defense for Youth organization, Bent Not Broken. And so I have a question for the prosecutor's office and the defender's office in relation to what strategies and approaches are your offices taking towards juvenile justice reform, and basically how are you guys working to properly represent youth within the juvenile justice system?
I'm happy to join the conversation from the defense perspective. I guess I will highlight the area where most recently we have been involved. I was actually in family court directly before coming here tonight. For those of you that are aware of the juvenile justice system, there are cases where the prosecution or the law designates juveniles as adults to be handled in adult court or in juvenile court, but as an adult. The Michigan Indigent Defense law provides that when a juvenile is charged as an adult, or they think that they may be charged as an adult, that juvenile is entitled to MIDC attorney defense. That means our office. So we are representing on those cases now, so we are actively involved. Those are only when cases get designated as adult cases. So I represent a lot of the juveniles here right now because our office is new to this and we're going to get up to speed. I anticipate within the year or two that they're going to find funding to do the juvenile defense what has happened to the adult defense and provide a more robust defense bar. It's interesting whether you guys know a lot about the juvenile process, but again, it seems like there's crimes where kids are told, hey, this is bad, you're just going to admit to it, but all you have to do is apologize or say you're bad. But as Jeff talked about earlier when he was talking about how they handle cases, that prior record variable, that what happened in your life as a kid, it haunts you, it follows you. And that's something that we need to be much more aware of. I think we over-police children. Things that when I was raised would have been a slap on the wrist or don't do that again. We litigate all too often now. And so my hope is that we can continue to be a voice not only for the adults but also for the juveniles. And right now we do it for juveniles that are charged with adult crimes. I tried a homicide case a couple weeks ago where my client was a juvenile.
We follow the law as it is. The law says if you don't obey a police officer's command, you're in violation.
But that only happens in our Kalamazoo community.
I wouldn't disagree with that for a second. I would not.
Sure. I mean, we obviously see that there's disparities. The toughest part, I think Jeff was very honest when he said that they do look at cases. I came from a prosecutor's office a county away in Kalamazoo, and I think that county authorized maybe 2 attempt RNOs. We see attempt RNOs all the time in Kalamazoo, which I don't think solves everything, I'm going to be honest with you, but it is at least an acknowledgement when you see attempt RNOs that somebody in the office, and again, he said it earlier when he talked to you guys about screening and the process, right? There are people that screen across the board for them, right? They have people like Jeff, who's been doing this for a long time, and we're probably less likely to issue certain types of crimes, especially the types of crimes that you guys are talking about tonight. And then there are other people that are younger or that come with different experiences. And so we do see discrepancies, but I'm going to tell you, as much as, I see pretextual stops all the time, and I think it's worth having conversations about pretextual stops, although legal under the law, they totally are, the impacts that those have. But the reality is the RNOs, they're attached to a lot of either driving crimes where people are pulled over, or domestic violence crimes. That's where we see them most of the time. Although I agree it does happen a lot in the community of color, I will tell you that it is just a charge, and it's one of those things where I don't envy being in a prosecutor's position at sometimes because they have, the people that are out there, the law enforcement, are a strong voice. And that is a reality that any prosecutor's office is trying to weigh back and forth. And, one, it doesn't justify decisions, I'm not saying that, but it just shows the complexity, and you guys are pointing out the complexities, right? Like, this is why, it's why I wake up in the morning and come to work, because these are life decisions that impact people for the remainder of their